see you. I think let's just give a minute for some more people to join us, and then I'll officially welcome everybody in a minute or two. Greetings, colleagues, and welcome to this workshop on the topic of is it time to reconsider the genetic link requirement for surrogate motherhood in South Africa? Welcome. Please note that this workshop is live streamed by UKZN and will also be recorded. By remaining in this meeting, you are agreeing to being live streamed and being recorded. Let us have a look at the agenda. First, there will be some critical retrospection on the case of AB versus Minister of Social Development that was before the courts about 5-6 years ago. This will be done in two phases. First, our first presenter, my colleague, Professor Amanda Boniface of the University of Johannesburg, will look at the High Court phase of the AB case. After that, Dr. Carmel van Niekerk of the University of the Western Cape will look at the Constitutional Court phase of the AB case. Then we will move on, and Ms. Aliki Etchkin, a doctoral research fellow here at UKZN, will then introduce the new case, the KB case that has been launched recently in the Mpumalanga High Court, and that will also, or that may also make its way to the Constitutional Court eventually. And then our fourth presenter is Dr. Bonginkosi Shozi, who is an honorary research fellow here at UKZN and also a researcher at the University of California in San Diego. And Dr. Shozi will explore the question of, is there a possible compromise solution to the issue of Section 2994, the genetic link requirement for surrogacy. So after the four presentations, we will then have an open discussion, and at the end of our discussion, I will give over to Professor Magda Slabbert of UNISA to lead us through forward strategizing. What are the next steps regarding this issue, regarding this topic? So just a few house rules. Please keep your microphone on mute. And if you would like to contribute during the open discussion, just raise your hand and I will allocate speaking turns. So everybody, welcome again. And without further ado, I would like to give the microphone to Professor Amanda Boniface.
Thank you, everybody. I'm just going to share my screen quickly. Okay, I just want to check that it's sharing.
We are seeing it perfectly. Thank you.
I have kept this short, as I was warned, 15 minutes or less. So I'm really just giving a very, very basic overview of what happened in the High Court case. If you do want to know a little bit more, I have put up the title of the article that this was written on in 2017 already in the SAR, the genetic link requirement for surrogacy, a family cannot be defined by genetic lineage. So if anybody does want to know more, that is the place to look for it. Very basically, the facts centered on Section 294 of the Children's Act that stipulates that there must be a genetic link between the commissioning parents and the gametes used to impregnate the surrogate. So briefly, it's that the first applicant was unable to give birth and was unable to donate her own gametes. So she needed both a sperm and an ovum donor, and IVF was unsuccessful. In fact, it's not for lack of trying, because the first applicant underwent 14 IVF cycles, during which she used both male and female anonymous donor gametes, in other words, the so-called double donors. And she was later advised that in order to become a parent and to carry a pregnancy to term, she would in actual fact have to make use of a surrogate. And she got legal advice, and she found out that she is in actual fact forbidden to use a surrogate to get a child in the same way, in other words, using double donor gametes, as what she was doing. Now, the legal question I've skipped over just to save some time. It is on the slides, but the basic legal question centered around the constitutionality of the section, which I just explained. So the whole question was, is the section constitutional? And of course, the answer of the court was no, it's not. But what I'm going to focus on is rather a little bit of the reasons for the decision, and then take it a little bit further and explore a possible right to a family that comes in here as well. So the basic reasons for the decision were that it infringes human dignity, therefore it's inconsistent with what is found in our Constitution. And the court in paragraph 76 expressly said that it excludes members of the subclass from accessing surrogate motherhood as a reproductive avenue. Now, the subclass that they're referring to is a specific class that the applicant fell in. In other words, she herself could not carry a child. She needed a surrogate, and she had to use also double donor gametes. So that is the subclass that they were referring to. They then took it further and said this also then prohibits people that fall in the subclass from exercising their right to autonomy, and also reinforces this negative psychological effect that infertility has on a person. You know, the example is this applicant tried 14 times with IVF unsuccessfully, and then wanted to try now surrogacy. Although there is a factual differentiation, the court also said, between self-gestation, such as what we could get in IVF, and surrogate gestation, the court here did hold that this, however, did not justify any legal differentiation. So the court said, yes, there is a difference between the two. We see there's a difference between the two, but this doesn't justify a legal differentiation occurring. There were arguments made by the opposition regarding supporting the genetic link requirement. Some of them are put here. The article and the case itself does deal with a number of them. Some that I mention here are, they said this would essentially be creating a new form of adoption. And of course, we know surrogacy is not the same as adoption. It's not the same in law at all. The court rejected that argument. They also argued that the child's constitutional rights would be infringed. So in other words, the focus here would have been the best interest of the child and the right to dignity. The court again disagreed with this argument as well, and that the child could be abandoned as there's no genetic link. Of course, the court disagreed with this as well, because many children are adopted and they certainly aren't abandoned because there's no genetic link. What I want to emphasize here is that the court basically said that a family is not defined by genetic lineage. They refer to various court cases. One of them is Satchwell versus President Republic of South Africa. One can go look at. They also looked at things such as the term family and saying that the term family means different things to different people. Also, family is not necessarily defined with reference to the genetic link between a parent and a child. And especially important is the quote that I've put there from paragraph 46, where they said that our society does not regard a family that consists of an adopted child or children as less valuable or less equal than a family where children are the natural or genetically linked children of the parents. So in other words, what they are saying is that these children are just as entitled to parental rights, responsibilities, etc., as what other children are. The other matter that I want to look at is the right to a family. Now, when you look at that right to a family, I think my screen share just went off. I'm just going to go in there again quickly. Apologies for that. Okay, I'm in again. I hope you can see it.
Yes, perfect.
Okay. So basically, the whole thing of family is not defined by genetic lineage, and that is what I felt the focus of the court case was. However, something else that needs to be mentioned here is that within South Africa, we don't have a right to a family defined as such. So in other words, there's no express right to a family. International documents, however, do protect the right to a family. There are many international documents found in this regard. So, for example, Article 23 of the International Covenant on Civil and Political Rights, the family is the natural and fundamental group unit of society and is entitled to protection by society and state. Article 18 of the African Charter on Human and People's Rights that stipulates the family shall be the natural unit and basis of society and shall be protected by the states. And then additionally, the Convention of the Rights of the Child and the African Charter on the Rights and Welfare of the Child, although don't define family, they do appear to recognize and protect the family as such. And the state also has a duty to protect children's rights by means of both international and national cooperation. And this you'll find in various documents, such as the draft provisional outcome document, World Fit for Children, and other documents that protect the family, such as the United Nations Emergent Issues for Children in the 21st Century, Universal Declaration of Human Rights, African Charter on Human and People's Rights, etc. However, the court in the AB case didn't refer to all these documents, and they didn't actually go into exploring whether there is a right to a family. They rather relied on the right to dignity of the commissioning parent as such. Now, South African case law has in the past relied on the right to dignity in order to actually protect what one could term a right to a family. And we have many examples of these. I'm not going to go into great detail in them. For example, in S versus Makwanyane, the right to dignity was defined as meaning everyone has the right to be treated with respect and concern simply because he or she is human. And the law recognizes that people have the capacity for creating lives of significance. And this means that, and I'm quoting from up here in Barrett, this means that people's autonomous choices must be protected and legally recognized so long as these choices are in line with the Constitution. And in Chairperson of the Constitutional Assembly, in recertification of the Constitution of the Republic of South Africa, they found the Constitution doesn't actually provide protection for right to family, but they did say that this most important right did relate to the right to human dignity contained in Section 10 and the child's right to family or parental care found in Section 28(1)(b). Therefore, it is of my opinion that the court in the High Court case was in actual fact referring to a right to family, because in South African law, the right to a family is often protected by the right to dignity as such. Some comparative law, I've summarized it very briefly, there's pages and pages of this, is that the court found there has been a recent move away from the genetic link requirement, and they looked at a number of countries. I'm just going to mention a few here. For example, they said in the United Kingdom there must be a genetic link, but it's restricted to couples. And 5 states in Australia say that no genetic link is needed for surrogacy. 2 states in Australia said a genetic link is required. In the Netherlands, a genetic link is required, but it's only applicable to heterosexual couples, and therefore the court held that would not be applicable to South Africa because it's unconstitutional. In Greece, there's no genetic link requirement. And not only that, but Greece actually has something called social parenthood. And I quote out of paragraph 52 of the case, this is where the child has no genetic relationship with his or her parents and where the family relationships are based merely on intent. And in the USA, we found some states require genetic links, such as, for example, Texas. Others don't, such as, for example, California. And in Canada, there was no genetic link requirement. The court did look at all of this and see what they felt was relevant. Right, I have sort of rushed through this, but the basics to sum up are that the legislator needs to recognize advances in reproductive and fertility technology. And we need to look at what the view of the family is based on what is actually occurring in society currently. How do we define the family as such? It's because now, in this case, in the High Court, they declared the genetic link requirement unconstitutional, but they said this was because it violated the commissioning parents' right to dignity. They also relied on the right to privacy and also the right to healthcare of the commissioning parent as such, and not on the right of the child as such to know the identity or origin, although this seems to have been the focus in European courts, which I haven't gone into detail yet about. However, we have to remember that in South African precedent, the right to dignity has often been used in the South African courts instead of a so-called right to family. Therefore, it is of my opinion here that the court was in actual fact saying that this infringes a right to form a family by restricting and saying that, a family is only formed if there is a biological relation.
Professor Boniface, thank you very much. Very insightful. We will now move to the second presentation by Dr. Carmel van der Kerk.
Good afternoon, everyone. Can you see my presentation?
it was up there and now it disappeared. Now we see you.
My apologies. My
Perhaps
apologies.
let's try again.
Okay. Let's try that.
Yes, there we see your presentation.
Thank you so much, everyone, for your patience. So I will be discussing the Constitutional Court phase of the AB decision. At the cuff, what I should say is that there were two judgments in this case, the minority judgment, which was written by Kampepe J, and the majority judgment that was written by Nkabenda J. Okay, so the minority had to decide whether or not Section 294 limited constitutional rights. The applicant in this case alleged a violation of a number of constitutional rights, in particular, the right to freedom and security of the person, the right to equality, the right to dignity, privacy, and access to reproductive health care. I'm going to deal with these as they appear in the judgment. So the first right to be considered was freedom and security of the person. Justice Kampepe said in paragraph 70 that it is the decision that is protected rather than a particular choice. Okay, what the court effectively had to do in her assessment was to decide whether Section 294 prevents a person from making a decision, whether that is in respect of reproduction, and whether this affects the psychological integrity of the person concerned. On all three counts, the minority found that these questions were answered in the affirmative. The court at paragraph 97 further found that Section 294 objectively limits the right to psychological integrity by preventing applicants and people in the same class from making decisions which constituted a violation of Section 12(2)(a) of the Constitution. Okay. So that was the first strike. Then the court had to consider whether or not there was a violation of the right to equality. The key issue was the fact that there was a differentiation between individuals who are conception infertile, as well as those who are pregnancy infertile. Interestingly enough, when IVF is used, individuals can use donor gametes from both gametes can be from a donor, whereas in the case of surrogacy, this is not permitted. So clearly there's a differentiation between the two types of means of reproducing. Okay, the court said that while pregnancy infertility was differentiation, what happened in the case of conception fertility constituted discrimination on an unlisted ground, and therefore there was a violation of Section 9 of the Constitution. In light of this, the minority found that it was not necessary to consider whether there had been a violation of dignity, privacy, and access to reproductive health. This is quite disappointing because by doing so or failing to do so, the court didn't really consider whether or not the right to dignity would cover the right to family life. Ultimately, the minority found that Section 294 unreasonably and unjustifiably violates AB's right to psychological integrity and her right to equality. They found that the declaration of invalidity, which had been found by the High Court, should be confirmed, but also found that it should be suspended to provide the legislature with an opportunity to reformulate the provision in light of this judgment. Okay. I've made some notes which are italicized, and I will get back to this later. The majority said that for them, the issue was on the validity of Section 294, and not about whether the genetic link requirement has relevance to the legal conception of family. I disagree, okay? But I'll get back to that. So what the court ultimately had to decide was whether Section 294 is irrational in terms of Section 9(1) of the Constitution. The majority found that this was not the case because Section 294 neither creates or compounds surrogacy. Okay. In paragraph 303, the court said it's that applicant's personal choice that excludes her and not her attributes of being infertile. But the reality is that she would not be considering these options or this option if she was fertile and could procreate in other ways. Okay. So ultimately, the court found that the provision does not discriminate against her or members of the subclass. Okay. So here, AB is not off to a good start as far as the majority is concerned. The court then had to consider whether her implicated rights were limited by the genetic link requirement. The court said, and I think they had quite a narrow interpretation of Section 12(2)(a), because they found that the decision relates only to your own body and not to the body of another. Okay, again, I'm not in agreement with this because the requirement is not that one's own body must be involved. Obviously, one cannot force a decision on another, but the surrogate would be a willing participant, okay? And so the decision would ultimately be about reproduction. It wouldn't be about whose body is implicated per se. The court also found that Section 27(1)(c), which deals to access to reproductive healthcare, was not limited to this right because they said there are other options available. And there was also found not to be a violation of the right to privacy. Again, the right to dignity, which I think would have been a valuable right to consider, was not considered in this instance. Now, because the court found that there was no violation of the above three rights, it was unnecessary to consider whether the rights should be limited. And so the court ultimately found that Section 294 does not violate the applicant's rights. She's free to consider how she becomes a parent. And the court said that the declaration of invalidity should not be confirmed. Okay. Now, in my critical retrospection, I highlighted 5 things. Firstly, the court's reference to legal conception of a family. From the decision of the majority, it seems that this is still based predominantly on biology. And by adopting this approach, what the court is effectively doing is it's rejecting numerous family forms that exist despite biology. Okay. Secondly, there's a reliance on different legislation as justification for the differentiation. The court tried to explain the one is regulated by the Children's Act, the other one is regulated by the regulations. But the challenge that this poses is that it creates a greater divide between the use of different forms of ART, and it perpetuates the problem that applicants such as AB find themselves in. Okay. Thirdly, the freedom to consider other means of becoming parents vis-a-vis freedom to make decisions regarding reproduction. The Constitution protects the latter right, okay? But compelling individual to consider other means deprives them of the freedom to decide how they would like to create or start a family. And because we haven't had adjudication on whether the right to family is essentially incorporated in the right to dignity, there is a bit of a gap in the middle at the moment. Then the minority judgment says that she was wanting to suspend the declaration to provide the legislature with an opportunity to reformulate Section 294. Regrettably, because the majority reached a different conclusion, there wasn't an opportunity for the legislature to do so. And so I think what we currently have is, with the current situation, is now another chance to see whether Section 294 can be amended to accommodate or to have a wider berth. And lastly, genetic links or biological origins. The existence of a a genetic link is not the only way to protect a child's right to know biology or their right to know their biological origins. If that was the case, then what about adoption? So I think the Constitutional Court missed a number of opportunities to develop the law, and it's left a lot of gray area for people such as AB who want to make use of surrogacy but are unable to do so. Thank you.
Thank you very much, Dr. van der Kerk. And now we will move on from AB to the new case that has been filed, namely the case of KB versus Minister of Social Development. It has been filed in the Mpumalanga High Court, but let me not tell the story. I'll give over to Aliki Edgecombe. Over to you.
Right, thank you so much for inviting me to look at this very exciting case. Just to reiterate, I am a doctoral research fellow at the University of KwaZulu-Natal, and I'm going to be taking you through KB versus the Minister of Social Development. So before you think it's a rehash of what has come before, it's a new constitutional challenge, and it has a unique twist on the AB case. But I'm going to let the story tell. I'm going to let the story tell it for you. So, like all surrogacy stories, it's a rocky road to parenthood for these individuals, and so is the case with KB. KB is a married 46-year-old woman. Her husband joins her in the application, and it's their desire to extend their family by means of double donor surrogacy. So a little background to this couple. They met quite a while earlier, but entered into a committed relationship in 2007, where they moved in together. They then got married in 2011, and it was from very early on that they decided that they wanted to start a family together. KB had no children. Her husband did have 2 children from a previous marriage. However, even from this early stage, they knew that it was going to be difficult. KB herself suffered from uterine growths and actually underwent quite a number, 4 myomectomies. Her husband had been diagnosed and treated for testicular cancer in 2000 and had also had a vasectomy, which he later reversed. And so it's with this backdrop that this couple endeavors to have a child. And so they undergo 5 years worth of fertility treatment. They desperately try to fall pregnant using their own gametes, and yet they're just met again and again with unsuccess. And so they refuse to give in. They approach another fertility specialist who tells them that actually their prospect of having children making use of their own gametes is very low. The issue is KB is now of an advanced age, her AMH levels are low, her husband's sperm is compromised. And so under medical advisement, they decide to make use of donor gametes, and they find suitable matches, and 7 embryos are produced. And so KB undergoes an embryo transfer, and it is a successful one. She manages to give birth to her beautiful baby boy in 2018, and this was a difficult pregnancy. She gave birth to him early. He was premature at 33 weeks, but she is excited and wants to give this little boy a genetically related sibling. So as soon as she is medically cleared, she goes back for further fertility treatment, and more embryos are implanted into her uterus. And once again, it results in a positive pregnancy. But unfortunately, at 23 weeks, she suffers medical complications which were life-threatening, and she had to have an emergency hysterectomy. And unfortunately, it not only meant the loss of her little baby girl, but all prospects of carrying any future embryos to term. And At this point in the story, the couple are very attached to these embryos. They see them as their own. In fact, in their documents, they often say they just want to bring their children home. And they also have a deep desire to give their little boy genetically related siblings. So the only option for this couple is, of course, surrogacy. And so this ends up being a constitutional challenge once again, and it's currently at the Mpumalanga High Court. Perhaps it will go all the way to the Constitutional Court. But KB, unlike AB, KB differentiates her facts from the AB case, and you'll see why she has decided to do that. And the first thing, she states that she agrees with the AB judgment, and her facts are different because she already has a child. And so she does see that the genetic link is in the best interest of the child. And so, as such, it should be extended to include a genetically related sibling. So in other words, to include a sibling link. So the argument goes something like this. So since it is in the best interest of a child to have a genetically related sibling, and since the courts should judge the child's best interest as being of paramount importance in all matters concerning the child, therefore, Section 294 offends her minor child's interests. In other words, because in situations that she is in, genetically related siblings, because in this situation she is precluded from the use of surrogacy, in fact, her child is denied the right to a genetically related sibling, and so his rights are undermined, his rights to equality and his rights to dignity. So what is their proposed solution? And it probably doesn't come as a surprise if you've looked at the arguments so far. The proposed solution is a reading in of a sibling link into the current Section 294. So not a striking out of it, just a reading in. And so what they've proposed to be read in is at the end of Section 294, or where the genetic origin as contemplated in the agreement of the child is the same as that of any of her siblings. In other words, so long as there's a child already in existence that will share a genetic link with the prospective child, then surrogacy should be allowed. Now, I'm not going to go into detail about critiquing this proposed solution because it will be done by Dr. Shozi, who is coming after me. But what I thought would be a good thing to introduce you to is some of the psychological evidence that was previously leveled in the AB case, but was not accepted by the courts at that time. Now, previously, the evidence that was leveled was psychological evidence given by Gollenbach and the Cambridge group, and they're the leading scientists in this area of what is called new family forms. So that includes all children born through donor conception. And she carried out this study over a number of years, 16 different phases. And at the time when this was heard in AB, she had completed her studies in children up to the age of 10. It did not include teenagers, and the court itself did not, the Constitutional Court majority didn't consider this evidence at all. And we'll discuss at the end, hopefully, whether they should have. It's been critiqued that they should have actually included this evidence. So I'm going to show you where this evidence has got us so far and whether or not the genetic link is actually a worthwhile conversation to still be having. Now, in terms of the research at its 6th phase of its longitudinal study, Professor Gollenbach interviewed children and families as close as possible as when those adolescents were in their 14th year, close as possible to their 14th birthday. Involved in this study were 27 egg donation families, 32 sperm donation families, 28 surrogacy families, and for good measure, she also had 54 traditional families, just to compare them against. And so the scientists actually had a number of questions. They wanted to know whether these children would be well adjusted, and all the earlier evidence presented actually showed that that was the case. These children were incredibly well adjusted. However, would that continue into the teen years? They actually weren't sure. And they thought perhaps, just like adopted children, these children too would battle to find their place in the world as a result of their donor conception. But of course, they were unbelievably surprised, because evidence showed that when they were comparing it to mother-adolescent relationships, so that's comparing how do mothers and adolescents correspond to each other and relate, as well as the adjustment of adolescents themselves, how are these young people doing? What we found is that actually there is no difference between those who are donor conceived and those who are part of traditional families. In fact, both of them scored very high in terms of positive mother-adolescent relationships, and both groups had really well adjusted adolescents. There was really no difference. What was incredibly interesting is that surrogacy families actually were the winners. In this case, it actually showed that they had less negative parenting. They had greater acceptance of their adolescents. So these mothers just accepted their children a lot more. And in general, these mothers had fewer problems in family relationships as a whole. And so while we might think that that is quite surprising, it's not considering how much those who undergo surrogacy actually put into it. They're motivated to be parents. And this is actually the comment that came through Gollenbach's research. She says, it is perhaps not surprising that these mothers' strong desire for a child translates into more positive parenting. So quite an interesting response, and actually a very positive one in the case of surrogacy, in that these mothers want to be parents, and this translates into them being better parents. With regards to the teens themselves, there was no difference between any of the groups, emotional or behavioral problems, or any of the adolescents' well-being, or they were actually just the same across those two groups. What was particularly interesting about Gollenbach's study, however, is that she asked the young people themselves how they felt about being donor conceived, or the circumstances of their birth, or the surrogate mother involved. And this was actually the first time that these young people had ever been asked these questions. And so, what do you think they felt about being donor conceived or being born by a surrogate? Quite interesting. Quite a few of them were actually very positive about it. They saw it as something about being special. They had a special way of being born, and they were different. But the most of them were actually pretty indifferent about it. They didn't really care. Finally, what's very important is that none of them were actually disturbed or distressed by the nature of their origins or their birth. And so also, just to pull it together, and the researchers stated that, although there has been much concern about how children conceived using reproductive donation would feel about their origins, the adolescents in this study mainly reported being unconcerned about their conception. And so it really leaves us with the question of, what impact does this evidence have on a child's best interest, on the debate of a child's best interest? I'll leave the major part of that to Dr. Shozi to take over, but it does raise important questions of how much value we are putting on this genetic link and whether or not we need to reconsider this altogether. So thank you very, very much, and I'll hand over now.
Thank you very much, Aliki. Our next presenter is Dr. Shozi, joining us from California.
Thank you, Dondrik, and good morning, everyone. Firstly, I'd like to prime you all and say my slides were nowhere near as impressive as Aliki, so anyone expecting me to maintain that standard, unfortunately, I am not as good as making things look pretty, but I hope to provide a similarly insightful discussion as I'm going to discuss the specific issue of, well, what should be the outcome? What should be the solution to remedy Section 294? From the preceding discussions, we've essentially arrived at a particular conclusion, or a couple of conclusions. Firstly, it's that while there were some interesting arguments raised in the High Court judgment in AB, many of these arguments were not fully explored in the Constitutional Court judgment, which have several deficiencies which were discussed by Carmel. So the question then becomes, well, what do we make of that? If we agree that Section 294 is in some way deficient, should we perhaps embrace the solution being proposed by the applicants in KB? Well, let's consider. In bringing their case before the court, the applicants in AB essentially base their case around the best interests of the child, or as they put it, the rights of the child. This, I think, was done for a specific and, well, fairly obvious strategic reason. The AB judgment was based on the rights of the parent in trying to overturn Section 294 and question its constitutionality. And given that the court dismissed it primarily, or to an extent, because it believed in this idea of Section 294 protecting the genetic link between a parent and a child, and that being in the child's best interest, the applicants in KB leans into that rationale, leans into this narrative that it is in the child's best interest to have a genetic link with their parents. And so essentially they say, we agree with this narrative, and take it a step further by essentially making the claim that if we want to ensure that the child's interest in having a genetic link to their parent is something that's both protected and promoted, well, this is a purpose that's advanced by allowing a single parent who, or in a circumstance where only a single parent can contribute gametes towards the creation of a child, to do so if there is already a sibling in existence that was created using donor gametes. This would then create a circumstance where that child would have a genetically related sibling, and both of them would be able to share in that genetic relationship between themselves and between potentially the donor as well. This is why they proposed their particular version of the amendment to Section 294, which I'm hoping to pull up if my slides respond to me. There you go. So I've just taken an excerpt from the papers there about how they suggested reformulating Section 294. You don't need to go through the entire thing, but essentially the critical aspects of this is that where the commissioning parents in a surrogacy arrangement would be a single person, then the court is, as suggested by the KB judgment, to be given the discretion to allow a double donor surrogacy where the genetic origin of the child is the same as that of one of her siblings, his or her. So again, the purpose of this is essentially to embrace this narrative. The best interests of the child are served by having a genetic link to both their parents and the people around them, and therefore we should allow them to have genetically related siblings with whom to share this genetic linkage. This solution presupposes a couple of things, and I want to really focus on two of them as they really highlight what I think are potential deficiencies in the solution proposed by the applicants in KB. The first is that it implies that the best interests of the child, as protected in the Constitution, are served by having a biologically related sibling. As has been discussed by previous speakers, the best interest of the child is protected in Section 28. And while the best interests of the child are paramount, it's not apparent that the best interests of the child are necessarily served by a circumstance that creates a genetically related sibling. I'll expand a bit more on why in the next slide. The second thing that this solution seems to presuppose is that the current circumstance needs to have an exception designed around it, because it's the only circumstance within which there's very good reason for deviating from the general prohibition established by Section 294. And so we see here a proposal for a very discreetly defined exception that would allow the applicants in KB to not be prevented from having another child. And this would definitely allow relief for them. But I think it's worth questioning, is it in fact the case that this is the only circumstance around which we should design an exception? Returning to each of these points, firstly, what do we mean when we talk about the best interest of the child? Well, our courts have a long jurisprudence on what they call sort of the child welfare principle, basically Section 28 of the Constitution. And one of the things that has been established as a principle in our law is that the best interest of the child does not simply mean something that benefits the child. Rather, the best interest of the child refers to a particular standard which prescribes the kinds of choices parents can make relating to their children. And what it amounts to in practice is that parents cannot make decisions which would compromise the welfare of their prospective child. So let's think about the circumstances of KB. Would it be the case that if the existing child didn't have a genetically related sibling, that their welfare would be compromised somehow? That doesn't necessarily seem to be the case. And the applicants in KB seem to be leaning into this idea that it's in the best interest of the child to promote genetic links because they're leaning into the rationale of AB. This is something I'm critical of primarily because I think this is where the court in AB erred, in fact, in constructing this idea that genetic links are in the best interest of the child without properly considering the evidence and whether child welfare is in fact dependent on a genetic link. Aliki has just quite clearly illustrated that if you look at the actual literature, it's not apparent that an absence of genetic links compromises welfare. And therefore, this equation between the best interest of the child and genetic links is arguably irrational and not really based on anything substantive. To return to the second point, even if we accept this idea that the child's interests are served by having a genetic link to a sibling, this aspiration for a genetic link with a sibling may be a good reason to depart from the general rule of Section 294, but even if it is, it's not the only good reason. For example, the factual matrix in AB is arguably another circumstance where Section 294 should have been departed from. And one can think of any number of situations where it might be that a child's interests would not in any way be compromised by the courts not insisting against one of the parents, or both one of the parents being able to contribute towards the gametes that are going to create the prospective child. Again, Aliki has just elucidated that the evidence of the development on children who are born from double donor gametes don't seem in any way to have their psychological development compromised. And so the question then becomes, well, what's the harm? Clearly, there are circumstances where this can go well. This comes down to the critical issue with Section 294 and the exception that has been suggested by the applicants in KB, namely that it's too narrow. And therefore, the proposal made by myself and Professor Delda in our submissions as part of the KB judgment is in which we are, I believe we're in the process of applying to the amicus curiae again in the High Court judgment. We were part of the Constitutional Court proceedings as well. We have suggested a formulation of an exception to Section 294 that we believe would help address the issues that are identified by the applicants in KB, but also addresses the more general issue with Section 294, namely that it does not provide the court with the ability to make a decision on what is in fact in the best interest of the child. And so we suggest that a different sentence be inserted to the end of Section 294 to the effect that a court may on good cause being shown, dispose of this requirement. The benefit of this kind of formulation is that it is not bound up in the factual matrix of the KB situation. And so we're not constructing a specific exception for a specific case as though it is the only valid case, but rather we're acknowledging that even if the general rule underlying Section 294 can somehow be rationalized, I point out I have my questions about that, it is nevertheless the case that courts should be provided with the opportunity to accommodate special cases, such as the one presented by the applicants in KB, and as well as other cases that may arise. And therefore, we will not be going against the legislature's general endeavor with Section 294, namely the preservation of genetic links within families, but rather creating a circumstance where courts can exercise their discretion. And in a sense, this would be embracing what it is the High Court is designed to be, the upper guardian of the child. And in those circumstances, make a decision about what is in fact in the best interest of the child, rather than assuming that it is always a genetic link. Thank you.
Thank you, Dr. Scholze. Colleagues, it's now time for our open discussion on this topic. So if you would like to make a contribution, please raise your hand. Who would like to go first? I see in the chats that we had a few comments. I think, let me just have a look. The last one was from our colleague, Dr. Soni. Oh, thank you, Dr. Soni, who says this is a great suggestion. Would you like to expand on that? Dr. Soni?
Thanks. Thank you very much, Danrik. I hope you can all hear me clearly. My connection is not the best
absolutely.
Today. No, I just agree that it's a great suggestion, because while I was listening to the facts of KB, the whole way of thinking and all of the research that's been done around this issue of a genetic link, it just makes me somewhat uncomfortable, because I feel that, the AB judgment at, the bare bones of the matter was that, how can I say it? It tended to undermine family relationships, how families are created, and the fact that genetic links aren't necessary if you do choose another option. And the court simply said, well, there are other options and you should exercise that, and kind of steered away from the fact that it is your right to choose a different means of assisted reproduction. It also ignored things like there's, no genetic link even necessary when a person uses IVF. And, the reason why I say that it's a good suggestion, because, it just sort of, it almost is a catch-all without being specific at all. It's going to cover applicants like AB, it's going to cover applicants like KB, it could cover individuals or couples whose situation isn't even, covered by either set of circumstances in these cases. But why, for me, I felt it's a better option is because I've seen, and that's why I have a little bit of a not the most optimistic feeling about KB, because I've sort of seen a similar kind of suggestion to what she's arguing, being argued in favor of sex selection for non-medical, non-therapeutic purposes, in that when the regulations to the National Health Act were being drafted, the regulations on artificial fertilization of persons, the stakeholders in industry were asked by the minister, by the department, what is your opinion? Should sex selection be allowed if a person wants to simply choose, if there's no medical basis? And they actually suggested, the South African Society of Reproductive and Endocrinologic Surgeons, they suggested the very similar kind of thing. They said it should not be allowed, but it should be allowed where there already is a sibling. So you would allow a patient in those circumstances to utilize that specific technology. And we know that that didn't happen, and it actually went to the other spectrum where it was legislated that it wouldn't be allowed at all. So that's why I say that the suggestion is, that would have my full support, because it is going to, it doesn't, because I think with AB, with KB, there's always, I feel, somebody that's not going to be covered by their suggestion, and relationships that would be undermined. If we've got that exception where a child it's in the best interest of the child to have a biological sibling, there's lots of children that don't have biological siblings, and as Aliki was saying, the research is showing that they've turned out great and they're perfectly fine. So in short, it's a great suggestion. Thanks.
Thank you, Dr. Soni, much appreciated, and thank you for your contribution. Any other contributions, colleagues? Perhaps some views from psychologists or from our colleagues who are healthcare professionals?
Hi, Donre.
Hello. Hello, Mandy.
Mandy here. Donre, I think it's a very good suggestion in terms of taking it on a case-by-case basis. I think SASREC is busy with the counselling accreditation for, we're doing that with the board. And I think, I'm not very familiar with which acts and which constitutions, etc., but it's going to put in for fertility patients to be counselled throughout their fertility processes from the beginning. And that'll give us more support to say that this patient has been guided through the process, understands what the next step is. Are they ready for donor gametes? Are they ready for, so it's going to come down to how they're going to be as parents. What is their parenting discussion? My problem with a lot of this is if we go this route, we take away from parents that there can be non-disclosure. We're going to have to disclose, and that's the same in the study that was quoted, is those children, remember, were all aware that they were donor gametes and obviously surrogacy. So we know in South Africa, a lot of our patients do not disclose that it's donor gametes. So if we're taking this on a case-by-case basis, I guess that would also have to be taken into consideration. It's going to have to be open disclosure, not necessarily known donation, but the child will need to know that they are of donor gametes if it's a case by case.
If I can put you on the spot and ask you the following question, the research that was presented by Ms. Etchcombe is on the research that was done by the Cambridge group, by Professor Gollenbach in Cambridge. So that was done in the United Kingdom. It was a critique in the AB case, or the concern was raised that that research is not necessarily applicable in South Africa. Based on your experience as a psychologist who has worked in the field of fertility treatment now for a very long time, do you think that that research is applicable to South Africa? Do you think that it would have yielded the same outcomes here or not? What's your experience?
Okay, in my experience in terms of surrogacy, there's openness, and that's what we encourage, and that's part of our application to the High Court, is the intended parents or commissioning parents need to disclose this to the child from the beginning, right? But in terms of donor gametes, I've been practicing for 28 years. They are not disclosing that. Not all of them. And so that's where my issue, I mean, we know the European movement by donor conceived adults is very much now for openness and disclosure, and that's the movement going around the world. So in South Africa, only slowly now are, with this DNA testing kits available to the consumer, only now are people starting to maybe be a little bit open towards it. But my experience thus far for 28 years has been the majority in this case will disclose surrogacy but not donation. Now we got a case going to court, which is AB, KB, whatever, the child is going to, you know, we're opening this up that we need to make sure that the parents are on the same page in terms of disclosure about all aspects.
I want to ask a follow-up question. Sorry to put you on the spot again, but have you ever engaged a case where a donor-conceived child who finds out that he or she is donor-conceived experiences that as negative? Or has your experience been the same as the Gollenbach group, namely that the children who know about their genetic origins are either not fazed by it at all, they're neutral, or they might in fact even be positive? What has your experience been?
So my experience thus far, up until about, I'd say 6 years ago, it has been non-disclosure and almost a secret. And the law has such maintained that we can do that because it's anonymous donation in South Africa. If I have a look at the movement more recently, especially since Carte Blanche and that study on the sperm donation, one sperm donor donating to 100 recipients overseas, where the same laws are not governing these cases. Since then, I've seen a marked disclosure or openness. However, so I don't have enough clinical experience on adolescents. If they are told from birth, and that's I'm encouraging my patients, there's certain books and literature that I encourage to create that cognitive folder from prior to even speech, to create that cognition. Those children that I'm seeing who are 8 or 9, who grow up with the cognition of there are different types of families, whether it be surrogacy, adoption, etc. Those kids are not presenting with additional problems.
That's very good. That's very good to hear.
The ones that are told later, I'm having with some of them, especially if their siblings are genetically related and they're told that they're not a donor conceived, that they're actually donor conceived, those kids seem to battle a little bit. So that's where the genetic link to the sibling is very important. I'm finding that the struggle is there between siblings.
So that's a very interesting context, because you're now referring to a case where there are already siblings that are genetically related, and then there are subsequent children for which the parents then use donor gametes. So they must then work out their position in the family and in the world.
Yes.
I understand, yeah. Mandy, thank you very much. Insightful as always. Other colleagues, please contribute. Any of our colleagues who are fertility specialists or embryologists who would like to contribute? How have you experienced this issue of the genetic link requirement? It has now been with us for a number of years, and it would, for instance, be interesting to know in practice at the fertility clinics, how big is the demand for people to make use of double donor gametes, both in the normal IVF context and in the surrogacy context? Can anybody give us a kind of an indication of their experience of that, please?
Enrique, I can make a comment. Tony Rodriguez here.
Thank you. Hello, Tony.
So from my point of view, we see more of that in the single woman situation, where they're using donor sperm and they've got a medical problem that we're not winning in terms of a uterine problem. So that is an issue. You don't know what to say to them, really, because the law is the law. You can offer them the option of going the constitutional court way, which is not a cheap way. So that particular group of people are really a little bit, they want and you say to yourself, well, why can't they just adopt a child? It's a totally different philosophy when you're controlling and in a situation where you've chosen your donor, you've chosen the sperm, like a couple who have to use donor sperm and eggs. What is different, really? And now they can't carry a baby. The situation is very much the same, in my opinion. You know, so they want to have the choice of the primary genetics, and they don't know much about it, but they want a choice. And then, but as fertility specialists, our hands are really tied. There is a law, and we've got to follow the law. I mean, it's a little bit. But having said that, we're happy to support all the work that's getting done on the back end from you guys, and I think it should be changed personally. But case by case, yes, of course. But then surrogacy anyhow is case by case, and it needs to go through a process, you know.
Okay. Thank you, Tony. Thank you very much. The floor is still open. Perhaps other lawyers or legal academics. I don't want to put people on the spot, but I know that there are some other leading academics here, like Professor Human from Stellenbosch. If you would like to comment on this topic, you'll be very welcome.
Thank you, Dominic. Can you hear me?
Yes, absolutely.
Well, I just want to say I'm older generation, so putting me on the spot causes a bit of trauma, but at least I found the unmute button. So
I apologize.
Yes, I find the solution very interesting, and I think it's something that I would like to ponder. What I like about the case, you know, the case-by-case kind of approach is, and it's something that you also mentioned now, adoption is case-by-case. You know, it is managed case-by-case, and why not a case-by-case approach in surrogacy? So I'd rather not include, you know, whether it's the best interest of the child that should play a role or anything like that. I just think it should be, you know, case-by-case approach. And but I think maybe, Donnie, the thing that's key to my own mind is once again the importance. The moment we talk about, you know, these kind of issues that are addressed this afternoon, the crucial importance for people with a legal background, medicine, psychology, and so on and so forth, to have these conversations and to drive change. I think this is crucial in the context of this particular discipline, and I think it's crucial as far as, you know, family life and children are concerned. So maybe I just want to end off by saying I would say this is my contribution, and thank you for bringing the experts together this afternoon.
Well, I absolutely agree. This is the way that we need to engage with these issues. You know, it's going to court now, and I think it will go through the court system. It will probably take another few months, hopefully not years, hopefully rather months. But there's a possibility that it might be referred back to Parliament. But I think the kind of engagement that we have here can be very, very useful to also inform the role players in this litigation. Hopefully it can come to the court's attention as well. You know, the more minds are involved, the better, I think. Colleagues, well, we've had some contributions. I haven't heard an embryologist thus far. Any embryologist who would like to make a contribution? I see that Dr. Wigendijk is with us, als Miss Els Smit, perhaps. Perhaps I should go back to our presenters and give each one of them an opportunity. You've now heard the comments by some of our participants, and in that light, let's start with our first presenter, Professor Boniface. In your presentation, you highlighted the importance of the concept of the family and the fact that the High Court did concentrate on it, although you also critiqued it from a certain perspective. If you must now apply that to the KB case, Professor Boniface, what would you say? If you were the judge, would you rule in favor of KB, and why?
Donna, before I start, I just want to say that there's road repairs going on. So if there's noise from the neighborhood, I apologize in advance.
No problem.
I definitely think, yeah, that you know, the focus actually needs to be a little bit broader simply than saying, you know, now there is an exception to this genetic link requirement because he has a different type of genetic link. I actually just wrote in the chat that I agree with Sonia, because this should rather be on a case-by-case basis in exactly the same way as what we deal with adoption. You know, we shouldn't solely look at something like, is there a genetic link? You know, there are many, many other factors that determine whether a child will, you know, have good family life.
Whether it's in the best interest of the child.
Yes. So to me, you know, we should move beyond simply saying, you know, this is genetics or this isn't genetics, and there is much more scope available for a broader way of looking at this and dealing with this on a case-by-case basis, exactly the same way as what Sonia said, such as what we do in adoption. I definitely agree with that.
Thank you, Amanda. Thank you, Professor Boniface. Professor Slabbert.
Hi, Donrich. I'm going to play devil's advocate. Professor Human or Sonia Human said that yes, the law must develop and the law must also drive change. But what about the law must also protect? Nowadays, you can go anywhere for your DNA to determine where you come from, your ancestors, your genealogy, or whatever. If this should be allowed, aren't we creating a lot of identityless children? I'm asking, and I would like reaction. Let's say I play the conservative one. If we allow this, then the child has no identity because there's no genetic link either from mother or father. And what at the end? Now they turn 16 and they ask questions and they go for the DNA. Shouldn't the law also have that part to consider in protecting the future children?
Very valid question, asked from the perspective of the majority of the Constitutional Court in AD. Thank you, Professor Slabbert. Who would like to answer that question? I see that, well, both Professor Human and Bongi and Dr. Shozi raised his hand, so I'll first ask Professor Human and then Dr. Shozi.
Thank you, Donrich. You know, talking about the genetic link, there's in any event in adoption, there is no requirement of a genetic link. And it is for the child to discover at some stage as a major, you know, who the biological parents are. So that's why I have a difficulty, you know, with adoption. And then in surrogacy, you know, focusing on the genetic links, it doesn't make sense. And therefore, I would propose, you know, a wider approach, as I said a bit earlier. So the genetic link and the as I say, you know, the distinction between adoption, there's no genetic link in any event. That's just my counter argument to the question posed to the previous speaker.
And I think another important thing, if I can quickly give my 2 cents worth, if we think back of the of ex parte WH, the court made it quite clear that the best interest of the child requirement is not this optimizing principle that everything must just be as ideal as it can possibly be. It's more of a sufficing principle, that it must be sufficient in our seen from the perspective of our broader community. It cannot, we can't expect that all parents must be able to provide a perfectly ideal world for their children. It must simply just be good enough, to put it in normal language. That would be my very brief 2 cents worth, but rather over to Dr. Shorzy.
Thank you, Dondrik. So a couple of very important points have already been made in this respect. I'll just also add to it by saying one of the issues with the rationale for Section 294, as discussed in the Constitutional Court, is that there was this equation of 2 things that are actually fundamentally distinct. On the one hand, there is having a genetic link to someone. On the other hand, it's knowledge about your genetic origins. Now, if we're concerned about the identity of the prospective child, what is significant in that regard is knowledge about genetic origins. And that is something that a child can have or not have, irrespective of whether they're conceived in the context of double donor surrogacy. So if our concern is identity, then perhaps we can introduce legislation about the necessity for disclosure. And in fact, there is some evidence that disclosure is in fact very important from a developmental perspective. But the issue is that Section 294 is not aimed at disclosure. It focuses on the existence of a genetic link and almost presupposes that the mere existence of the genetic link is beneficial to identity formation. Well, that link can exist. However, a child is simply ignorant about their genetic origin, in which case we are, as Magda put it, creating identityless children. So if that is in fact an important governmental purpose, Section 294 is not designed to further that purpose.
That's assuming that knowing your genetic origins is in fact so important to develop your identity. But
Absolutely.
then, as you've said, even if we assume that knowing your genetic origins is important to forming your identity, then that can be accomplished in other ways, such as, for instance, ensuring that you make use of a known donor instead of an anonymous donor, because then, and then of course also enforcing disclosure so that the child will then know and will be able to, but that's almost a different debate. Well, whether that would be a good thing or not, I think the point is only that enforcing the genetic link is clearly not the only way to accomplish knowing your genetic origins.
Indeed, it's not a way to accomplish it at all.
Exactly, because even if there's because if you don't enforce disclosure in any event, then one can ask what purpose it serves. Colleagues, it's already past 4, so it's time now to conclude. But first, if I can ask Michaela, put up the poll so that we can vote. We've prepared 3 questions for you. So I would ask you to quickly, it will take a minute to do these questions. And based on your answers, I will then ask Professor Schlabbert to facilitate the last part of this section, namely forward planning, forward strategizing. What are the next steps that we can take? But let's first do the poll. Most of the people have finished, but I'll give another half a minute or so. Okay, I think we've had enough opportunity. I'm going to end the poll and then we'll have a look at the statistics. Okay, I think just confirm, can everybody see the results in front of them? Michaela, if you can perhaps just confirm that everybody is seeing the results.
Yes, everybody should be able to see them.
Okay, 100%. So let's quickly look at them. So the first question: do you feel that a genetic link is important in securing strong family bonds? There, the majority indicated somewhat. It depends on the individual or family. And the second most people indicated no, it's irrelevant. Then the second question: do you believe studies on children's psychological development in other jurisdictions are relevant to determining whether the genetic link is necessary to safeguard the best interests of the child? So again, three possibilities. With a very, very high majority, the winner is somewhat. These studies are relevant, but the context and values of South Africans should also be considered. Then the third and last question: in the regulation of surrogacy arrangements, what solution do you feel best serves the prospective child's best interests? There, with a slight majority, it is the last one. The court is given discretion on a case-by-case basis to depart from the genetic link requirement where good cause is shown, with two of the other potential answers, such as, well, the second one is then genetic link requirement scrapped in its entirety. That was supported by 27%, and then 17% supported the genetic link requirement is extended to include a sibling link. Good. Colleagues, thank you very much for participating in this quick poll. It is always good because everybody gets an opportunity to participate in the discussions. It's just good to quantify the views of everybody present here at the end of our discussion. So I'm going to give over to Professor Slabbert to discuss with us in the next 5 to 10 minutes some forward strategizing. What do we need to do? Over to you.
Thank you, Donrich, and I think will be quicker than 10 minutes. Yes, and I want to emphasize I was just the devil's advocate to ask, because when I speak to the general public, not people interested in this field or whatever, sometimes their eyes go big and they say, no, this is going too far or whatever. So I was just throwing it in there to get a little bit more of a debate. But yes, thank you very much. So when I look and summarize and pull together what was said today, is what is necessary is a new look at what is a family. So maybe there should be more research, more students should write about, specifically from maybe an African perspective. What is a family? How is a family seen nationally and internationally, and especially how the law sees this? And I know I've written an article, who at the end of the day decides whether a person should be buried or cremated. And I came across this same issue. What is a family? How do the funeral undertaker which one is the family that makes at the end of the day the decision, especially when there's contradicting views. So I think there's research necessary on the definitions, specifically a legal definition of what is a family, as well as what is a family then in an African context. Not necessarily that there will be a difference, but at the end of the day, we are on the African continent. And then, as I've said, with specific emphasis on how the law should view a family. Then the psychological evidence from overseas, it's very interesting that the people said it must still be relevant to our specific situation. And that is a sort of a conundrum or a stalemate situation, because as the psychologist said, when there's no genetic link, or when it's donors, either a egg or the sperm, that it is a secret and people are not open about it, whereas with surrogacy or adoption, people are more open. So yes, there's a definite need from the psychological side to find out how do people in South Africa or children in South Africa then feel, which might be very difficult as it is not in the open. As I've been indicated, maybe a change will come eventually. Then what also came out from today is that the KB case is good because it's another challenge to court. But as Dr. Shorzy pointed out, it is too narrow. If we stick to the facts of the KB case without you getting involved as amicus curiae, we will go in the sort of same circle. We will get a judgment as we got with the AB case that will be too narrow, and it will not solve the problem, because another person will just come to the fore and say, well, I've now got another set of facts, and then we will have to go to court again. So I think the agreement of everyone who participated today is that you should definitely be linked as amicus curiae, ask permission to be amicus curiae, and then drive as everyone have said, that the court, they must change section 294, that it must be on a case by case requirement. In what you've said, a court may on good cause shown dispose of this requirement and argue for that, because then it will open it more up for other people with other sets of facts, and from there on it will go on. So I think that the statistics have also shown that that is the way to go, to have it not once again narrowly only a judgment for KB, but you as amicus go and try to say that on good cause shown they must be disposed of that requirement. As in my summary, this is the general feeling of all participants, and in the interest of justice. Otherwise, we just go in circles. Thank you,
Professor Slobert. Thank you very much. Thank you very much. And also thank you for being devil's advocate during our discussion. It's always good to have a devil's advocate in such discussions. So we've reached the end of our workshop. To all the participants, thank you very much for participating, and to all the presenters, thank you so much for preparing your presentations, and for Professor Slobert for doing our summary, our forward strategizing at the end. Colleagues, thank you, and I wave goodbye. Take care. Bye-bye.
Bye.